Mrs. Moore was charged with some type of cruelty to children or charge. And when people have to pay child support and alimony, sometimes they have to take extra steps to support their family and to pay their own bills.
Mr. Moore can't say, I'm going to quit. I'm going to quit the job because I don't want to pay child support.
Here's a guy he's making $19 an hour. He's working 65 hours a week. And then he might have been able to quit that job years ago, but then he was ordered to pay alimony and child support of $1,200 a month and $600 plus a month in alimony. Judge, he only nets $2,000 a month. So if he doesn't work a part-time job, he's not going to get by. It's not fair. There's nothing inherently fair. So because you work harder, you're going to keep working harder and paying more money.
My client is asking for attorney's fees as well.
Or is it your testimony before this court that it's Mr. Moore's fault that you were charged with cruelty to children?
Yes.
The latest update that all matters were resolved except the issue of child support. Where are we on that?
Well, good morning, Your Honor.
Good morning.
Good morning, Your Honor. The parties have reached an agreement on modification. They did follow the guardian's recommendation as to the children. The only issue is that there's a disparity in income. Just to briefly, my suggestion was to just take the difference in the income and have Mr. Moore pay that. And there's a dispute about that. And I believe that Mr. Moore just quit a job that he's had for years. So that's an issue as well. But that's the only issue before the court is child support.
Okay, Mr. Campbell.
So, Judge, if it may please the court, Rick Campbell for Mr. Moore. Judge, would you like us to make our opening statements?
Yeah, you can. But before we do that, I know we had the guardian ad litem, Ms. Wright, here, and I know Ms. Wright's position was generally dealing with
That's right.
modification. And so I want to know, is she necessary?
No.
No,
Okay.
Judge.
Mr. Campbell.
No, Judge.
All right, then. Thank you very much, Ms. Wright. You are free to go. And you look pretty this one. You always look pretty, but your hair looks flawless, even more flawless today. How about that?
Thank you, Judge. Y'all be good.
Take
All
care.
right, bye-bye.
Yes, let's start with the openings. And you can also mention to me what the modification was that you all came to as an agreement.
Yes, Your Honor.
Thank you. Go ahead.
All right. Well, good morning, Your Honor.
Okay.
Judge, this case was filed in May of 2022. It started out as a complaint for modification and child support due to the fact that the original divorce decree, which was entered in September of 2021, and I think the settlement agreement that went with that was filed. Well, that's right, Judge. The divorce was September of 2021, involved two girls. At the time of the modification, the older child, Sine, filed an election to live with her father. And
how old is Sine?
Sine is now 15, Judge. I believe she'll be 16 in July.
Okay.
Mr. Moore, you're shaking your head, so I think I'm right. And I believe Skylar is 9 going on 10.
Correct.
She's the youngest. So, Judge, after the case was filed, and I believe there was a bond issued because Mrs. Moore was charged with some type of cruelty to children or charge, and Ms. Foster will correct me if I'm wrong on that. She's got some documents in her exhibit list showing the disposition of that case, but I believe for quite a while there was a bond restriction involving the older child who has been living with my client, Judge, now for almost a year. So, Judge, this case has been going on for a while, and with that, a guardian was appointed, as you know, Ms. Wright, and eventually she made a recommendation that confirmed that Sine wanted to live with her father. She's been doing that. And that Skylar would stay with the mother, and my client they would both have every other weekend visitation, to the point where both girls are in the same house on the same weekend. Mr. Moore will testify, Judge, that I don't know, due to Sine's age, I believe she sees her mother more or less irregularly, but he sees Skylar every other weekend, pretty much like clockwork. Mr. Moore, Judge, works and he did at the time of the divorce. He works for the Department of Labor as a system security administrator. We'll introduce his pay stubs. He gets paid twice a month, and his pay is exactly the same every paycheck, twice a month. It adds up to about $6,578 roughly. A couple of cents less than that.
Give me 1 second, Mr. Campbell.
Sure, Judge.
All right, go ahead.
So, Judge, his income is exactly the same every month. So it's very easy to show what his income is. That's not going to be difficult. As a matter of fact, Judge, his testimony is going to be, he has no, even in the horizon, there won't even be any increases. He's already at the plateau. The only way he can ever get more money is if his manager quits, and which he says is not likely to happen anytime soon. So his income is fixed. And Your Honor, I guess the reason why we're here is because at the time of the divorce, Mr. Moore was ordered to pay over $1,200 a month in child support and $600 a month in alimony. And his alimony is going to end, I think, in December of this year. So he has maybe 10 months more to go on alimony. And his child support was $1,200 plus a month. So, Judge, with that, making and at the time, he may not have been making as much as he's making now, but it's roughly this. Let's just assume it's close. After taxes, and we'll look at his net income in a minute when we introduce evidence, but after taxes, if he's paying over almost $2,000 a month after tax dollars to pay his support and alimony, Mr. Moore did all he could do, which was get a part-time job. And so on and off over the last 5 years, he's worked as a clerk in a tobacco shop called This, That, and the Other tobacco shop, making $16 an hour. And he would work mostly during the week, get some weekday hours. Can
I stop you real quick because I'm getting a little confused as to what the outstanding issue is. I thought the outstanding issue was determining how the court would handle the fact that one person has one child, one person has the other, and what the difference is. What difference does it make to me about the testimony of how many hours he worked a week?
Oh no, Judge, I was
Really,
showing the court why he had a part-time job, because recently he quit that part-time job. He's got his daughter. It's taken a lot of time during the week and Saturdays. And Judge, we have the incomes. And apparently the testimony is going to be, I believe, Miss Moore, who works for State Farm, just got a new position offered. So we have her income. I think the reason why we've been held up on this with different offers going back and forth is because Miss Moore, we're here today because she wants to base child support on Mr. Moore working 20 to 25 hours a week at $16 an hour overtime. And she, based on the income records I've seen for her, she sometimes gets close to 40 hours a week. So she wants to base her child support that she pays for the oldest at almost 40 hours a week. But she wants my client, Mr. Moore, to pay child support based on almost 65 hours a week. And that difference is substantial.
okay. So I now understand. Okay, I didn't understand that there was a conflict as to what his income is. I thought that there was a conflict with regard to how the court should handle the 50-50
No, Judge.
custody, because I was thinking that is that's a formula that I use all the time. I have generally the same way of handling it. That is
Right.
I take
So, Judge, right. And I'm
that
sorry.
if they're making about the same. Anyway, so that's generally how I would handle that. But you're saying that there is an issue about how much he makes.
No, Judge, I think the issue is going to be the defense position is, Judge, when he's paying child support for me, for the youngest, Skylar, he should be paying based on an income of 65 hours a week of overtime. And I should only be paying him for Sine, the oldest, based on a full-time 40-hour-a-week job. And he just left his job. So I assume they're going to argue, oh, he just left his job, but he should be held to that. And all along in this case, we can't understand on why, and I guess this is the argument, Judge. Defense wants my client to pay more child support because he's working more hours overtime, in part-time job, to be able to pay the child support he's already paying. So since he's working overtime, he makes more money. We want him to pay more money for child support because of that. So now he's going to have to keep working those hours to pay the child support that he needs to pay because he's working overtime. It's a circular argument. And it's like, now I have to work overtime. It's a choice that I made before so I could break even every month because I was paying alimony and child support, a very high dollar amount. Now, assuming he's going to have custody of one and the offset is maybe a couple, $300. If I'm not paying $1,200 anymore, I can spend time with my family and my girls and I don't have to work weekends. But Miss Moore doesn't.
Is that his position?
Yes, Judge, that's one of the reasons. And plus it was an elective job, Judge.
No, what I'm asking is generally, if you're telling me that if he did not pay this child support amount number, he would not work that job. Is that what you're saying?
And he's already made that choice, Judge. He left them a couple of weeks ago or more. Because he was making $16 an hour working as a clerk selling tobacco products, Judge. That wasn't a lifetime goal. But Miss Moore wants him to say, well, you made that money. Now I want you to pay child support based on that money.
Okay, that's interesting.
Yeah, because you made a choice.
The second job is the overtime job, which he quit. And your position is that he shouldn't be held to that second job, because that was something that he just was electing to do, not something that he
and he didn't really have a choice, Judge. With the amount of money he was paying, he couldn't break even. He's living at a house with his cousin who's barely able to pay any rent, and he doesn't have a place to live in like Miss Moore does, his own house, and his daughter's got a place. I mean, they have a nice family there, and he's comfortable. But the point is, it was a choice. And if Miss Moore has
one second.
Yeah. So, Judge, basically, the evidence is going to show that for reasons that were pretty much just out of necessity, sheer necessity, Mr. Moore made a choice of working a part-time job. Miss Moore, on the flip side, Judge, she says she needs money or whatever her situation is, but she also has a choice. And I guess her choice is not to work a part-time job. But so she wants the court to base child support on forcing Mr. Moore to continue to work 20, 25 hours a week in a part-time job so that he can pay a higher dollar amount to her for child support. That if he didn't work that job, that money wouldn't be included. He's got a full-time, respectable job with the Department of Labor. He makes $6,500+ a month, more than she makes. I think her income was somewhere around the $3,700, $3,800. We'll look at the child support worksheets in a minute. So, Judge, to us, it's kind of astounding that we're here on this issue today. When people have to pay child support and alimony, sometimes they have to take extra steps to support their family and to pay their own bills. And so now she says, well, because you've done it historically, I want you to keep paying that dollar money so that when we're both paying each other child support, your dollar amount is more than you have to pay me more for Skylar based on you working more hours. I would challenge Miss Moore to say, then why aren't you working 25 hours? You can take your free time, and when you get home from work and spend time with your family, you do what you want, but you're asking this court to tell Mr. Moore, you don't have a choice now, because unless you work that part-time job, you're not going to be able to afford the child support. And that's why we're here today, Judge.
Okay.
I'm a little, it just doesn't seem to me that it's that hard.
Okay, thank you.
Your Honor, if I may, just a brief opening,
Yes.
just to address how we got here briefly, because Mr. Campbell brought that up. My client, the parties were divorced in 2021. My client has had custody of the two girls. My client's home is a bit more structured. And there was an incident that while the parties were visiting or having parenting time with their father, where the oldest daughter ran away. Mr. Moore called Miss Moore and said, "Hey, she's missing." My client went over there to find her daughter. When she got there, she finally found the daughter and she slapped her daughter. Mr. Moore waited 2 weeks to call the police, and a warrant was taken out because it was on video. Waited 2 weeks to call the police. A warrant was taken out for my client. She was arrested, and there was a bond condition that said that she initially was no contact, and then it went to no violent contact. So the oldest daughter does enjoy living with her father because she has more freedom. And however, the charges that were brought against Miss Moore by Mr. Moore have now been dismissed. That's what Mr. Campbell was talking about. But Your Honor, just to kind of get to, so the parties, and there was also a contempt. Mr. Moore was in contempt. We've resolved that issue regarding the contempt. It's part of the final order. So child support, Mr. Campbell is correct. It should be just easy. You plug in numbers. When the parties divorced in 2021, Mr. Moore's income was $7,574.53.
Sorry, how much was it?
$7,574.53 is the amount that was entered in the child support worksheet that was submitted in the divorce. At that time, that was his income. Mr. Moore is now saying that he got a part-time job. So we did discovery, and I just took the numbers that he provided as to his income. The same with my client, took the numbers that she provided as her income, and it was entered into the worksheet. Mr. Moore's income as of January of 2024 was $8,134 a month. That's the number. $8,134 a month. And I just took what his attorney provided me and I entered that into the worksheet. I did the same with my client and entered it into the worksheet. And I said, hey, let's just take the difference. However, as of January 4th, Mr. Moore apparently has quit the part-time job to make his income less. Interesting enough, his income is now less than what he even made during the divorce. He wants the court to believe now that he only makes $6,500 a month, when during the divorce, he made $7,574. And as Mr. Campbell said, his income has not changed. So it's interesting to me that now he wants the court to believe that he makes less than what he made during the divorce. But Your Honor, this should be easy. It's just plugging in numbers. And it's not that Ms. Moore wants to use 25 hours. We just use what they submitted as their income. And we're asking the court to follow that. Mr. Moore can't say, I'm going to quit. I'm going to quit the job because I don't want to pay child support. And even in the response from his employer, the evidence will show his employer says, oh, you can come back anytime. And we believe that after this case is finalized, he's just going to go back. This is a job that he's had for over 5 years.
What?
I'm actually the part-time job that he has working at the cigar shop.
The part-time job he had before the original 2021 matter?
Yeah. Yes, he's had this job for years.
Yeah, there's no more. We don't really need to go any further, Mr. Campbell. It'll be a waste of time. If he had that job before the 2021 case, and that was the figure, and now he quits it, that there's no need to go through that.
Well, Your Honor,
I don't
respectfully,
see how he
Judge,
can have a need if he had it since 2020. If he had that same job 5 years before this 2021 case.
yeah, but Judge, wait, Judge, and wait,
I don't
Mr. Moore, wait, you'll get a chance. Judge, and I wasn't the attorney when he got divorced. There's probably all kinds of reasons why when the family's together, he's trying to make more money. Okay? I mean, here's a guy he's making $19 an hour. He's working 65 hours a week. And then he might have been able to quit that job years ago, but then he was ordered to pay alimony and child support of $1,200 a month and $600 plus a month in alimony. Judge, he only nets $2,000 a month. So if he doesn't work a part-time job, he's not going to get by. And his paycheck, and the reason counsel's, this is disingenuous, Judge, to say, oh, let's just plug in the numbers. We've been going back and forth on child support for months saying, we don't want to include his part-time job. That's not fair. There's nothing inherently fair about saying that a guy should work 65 hours a week to her 40, just because he's historically done it. He's going to be obligated to that for 9 more years.
Okay, I'll let you present it. I just know that there's case law on that. If you got a history of those part-time jobs, then that's what you use. I don't know how. My concern is that this is just the legal it becomes a legal argument rather than factual. If he's had the job for 20, if he's had the job for 5 years and then just decided in the middle of the modification to quit it, it would be one thing to me if he quit the job because he was tired of working, whatever, and then asked for a child support decrease because of the fact that, you know, he's no longer interested in working his part-time job, but he had it before the 2021 divorce.
And Judge, now he's got custody of the oldest. She's
Yeah,
living-
and I was going to use that number to offset the number.
Right, and I know, but Judge, we
But-
get that part.
But I might be wrong.
Judge, we get that part. So he's got the older child. His alimony starting will be gone in 10 months. And some of the reasons why, with the offset, he's not going to have this huge amount of money anymore. And he's like, why? Basically, what we're sending a message to Mr. Moore that when you work harder to try to get by, and he's working harder because he's paying his family's bills, his alimony and his
Right.
child support. So once he goes to work and pays those, he needs some money to pay his own bills. So he's not behind in child support. He's not behind in alimony because he's been working hard for 5 years just to keep his head above water, living with family members. He doesn't even have his own home. So now we're going to say, Mr. Moore, you work a lot harder than Mrs. Moore does, but you're going to be held to a higher standard for the next 9 years because you've worked hard. You work more hours because you had to support your family. So because you work harder, you're going to keep working harder and paying more money because you tried. So now that you've been able to work 65 hours, that's the choice that you had to work those hours to get ahead. You don't have the choice anymore. Now you have to do it or you're not going to be able to afford to live.
Okay. All right. Continue.
All right. So Judge, if that's it, I'll call.
I'm gonna let Ms. Foster finish
All
and then
right.
we'll start with the testimony.
That's it, Your Honor. We believe that we just want to plug in the numbers. We use the numbers that he provided with his part-time job that he had even while they were married. And that's it. My client is asking for attorney's fees as well, for having to argue this child support portion. And Your Honor,
Okay.
that's it.
And Your
So
Honor,
here-
we're also seeking child support for the entire case. This case is going on for 2 years and the child's election was evident. And Judge, I didn't get into that because we
You
released.
said you're seeking what now?
We've also filed a petition for attorney fees for both the modification of custody and child support.
Well-
I didn't get into the issue of the custody because we released Miss Wright. But Judge, this case was much more than a slap. There's a video. She punched her daughter in the face, and the daughter wanted to live with him. So it took 2 years to get an agreement that and a guardian, tons of expense to tell this older girl what she could and couldn't do. It was very evident right from the beginning she wanted to live with her father. But 2 years later, we finally get an order.
Okay.
for
So we
custody.
could deal with the child support later. I had another matter that I have to take care of. They're coming in on Zoom with this child support issue. I plugged it in for about a 30-minute or so hearing, but based on the fact that you're telling me, because I thought it was a simpler issue. I thought it was one that the court would decide. I thought it was simpler. But it looks like we're going to have to get historical information, which means testimony is going to be long because I would have to delve into what his income has been prior to the 2021 divorce, and kind of look at that issue. And then generally, the reason I'm listening, Mr. Campbell, that kind of stopped me is generally if someone quits a job, I don't even consider it. I mean, I don't even think through that quit because the statute is very clear. If you quit a job, you just quit it. I still look at that income because you can't just voluntarily quit a job. You're supposed to still look at the income that they had despite the voluntary quitting a job. So I'm thinking this is a simpler issue, but it's not. Your position is that because he works over 40 hours, that the court should be looking at only a 40-hour week. So I need to go back and kind of look to see, because generally I look at what you brought in, and if you quit the job, you just quit the job. But the number is what the number is. Your position is that if he quits the job over 40 hours a week, then that should not count against him. So I need.
And Your Honor, even if you include it, there can always be a deviation because it's just inherently unfair to say to him, your child support is based on 65 hours a week or more, or 60 to 65, and hers is based on barely 40 because she chose not to work an extra job, but you did. You were industrious.
Your Honor, I'm gonna
But
object.
we'll get into it. The thing is that stopped me was that it was something he was already doing before the divorce. This is how he cared for his family. And so the idea is for example, I've had people that have worked, 15 years, the same two jobs for 15 years. And then the day of the child support, they quit the second job.
But this is a modification.
Yes, I understand.
So it's child support.
There was a case that I reviewed that was a little different, but your position is that it was only for 5 years and that his income, so we'll have to see. So I need to look at the numbers. What I'm asking for your indulgence is because that's going to take me a little bit longer than I anticipated. I have another case that they're appearing via Zoom and I'm trying to work around her work schedule. So I need to take her testimony.
Judge, we can wait.
I'm gonna ask that you all just appear back at 11 and see where we are at that time.
Can you please state your name?
Danterio Moore.
And Mr. Moore, you're the petitioner in this modification case against Mrs. Moore?
That is correct.
All right, and Mr. Moore, where do you live?
2489 Old Orchard Court, Dunwoody.
All right, and is that a premises that you share with someone else? Do you own it?
No, with my cousins.
So your cousin owns it?
Adult cousin, correct. Yes,
And you have a room there?
Yes, I do.
And does your older daughter Sine live with you?
Yes, she does.
And does she have her own room?
Yes, she does.
And how long has she been living there in Dunwoody with you?
Since May of last year when school got out.
May of 2023?
Correct.
But you filed this case for modification, I think it was in May of 2022?
Correct. That is correct.
Yeah, May 18, 2022. All right. And you had filed an application for custody of your daughters?
That is correct.
And was that based on your daughter's request to live with you?
That is correct.
And was it also based on a situation that happened between your oldest and her mother?
That is correct, where she couldn't be around her mother, so she was living with her grandfather.
And then she came to live with you after school last May?
Last May, yes.
All right, and where does she go to school?
Midtown High School.
All right, how does she get there?
I take her.
How does she get home?
I bring her home.
Okay, all right. And the judge, this is just for way of background. These issues have been resolved. I'm just trying to give the court a little bit of idea what's going on with the child, because it relates a little bit to child support. And does your daughter have a summer job coming up?
She does. She works for the City of Atlanta Recreation during the summertime.
Okay. And you just entered into a consent parenting plan regarding custody and parenting time with both daughters. Is that correct?
That is correct.
All right. And I'll just try to move it along. So is it the part of the parenting plan that you have primary custody of the older Sine, and then Miss Moore has primary custody of the younger one, Skylar?
That is correct.
So how often do you see Skylar?
On schedule, it's every other weekend. And, whenever the parenting plan says, like, if I get Father's Day or if it's my break or whatever, I don't have any issues getting her at all.
Does the parenting plan provide that both daughters are at the same parent's house every weekend? So when you switch them, are they going to be both the daughters with you and then both daughters are with her?
It's supposed to be that way, correct?
All right. So in actuality, is Sine seeing her mother on a regular basis?
No.
How often does she see your mom?
When her mother makes arrangements for her to be picked up, because as it stands, she is not to be with Sine without a guardian. So usually what happens is I'll go and pick Skylar up and and bring her back to my house. And when Sanae's supposed to be with her mom, she'll send someone to get Sanae. Is it consistent? No, but has it happened? Yes.
All right. I guess my point is that still because of bond conditions, or is that because just how you all work it out? Because I was told the case
Objection
is
calls
both.
for speculation.
Well,
Well,
I'm
you know,
sorry, one second.
I'll withdraw the
I'm sorry,
objection.
can you all hear me?
yes.
Yes.
All right, yes, go ahead. What were you
Yeah,
saying?
I'll withdraw the objection, actually.
I was
Well,
just, Mr. Moore, I was just trying to get the lay of the land. Is it your understanding that the parenting plan is now in effect and all the bond conditions have been removed, or what do you know?
the parenting plan is in effect. We signed it. I think it was November last year, 23, and as far as the bond condition, actually, I just recently got a call from the prosecutor's office, and
No, wait.
and as far as
All right, go ahead.
as far as I was told, nothing has changed about the bond, so that is still the same.
All right.
Well, objection, hearsay, and also just hearsay, Your Honor.
Well, that's
Okay,
okay. And
let's just move,
counsel,
let's move,
Yeah.
let's move away from that,
All right.
Mr. Campbell.
all right. So, Mr. Moore, where do you work?
At the Georgia Department of Labor,
All right, and how long have you been there?
almost 10 years.
Say that one more time, where did you work? Where do you work?
The Georgia Department of Labor,
Okay,
All right. And you said you worked there for how long?
almost 10 years.
All right. And what is your job description?
Security system administrator.
Okay. And how much do you earn per month?
At the Georgia Department of Labor, it's a few dollars over 6,500 monthly.
So, Mr. Moore, this pay stub, if you double it per month, that's how you got the number on your financial affidavit
That's correct.
of the 65, 79, 60?
Correct.
All right. You sound like you're very far away. Maybe it's just mine. All right. So, Mr. Moore, do you have is there any chance of any increase in your income at the Department of Labor?
Objection calls for speculation.
He might know. You can.
Yeah, Judge, I think he knows.
Okay, go ahead.
Well,
Mr. Moore.
The position that I'm currently in, there's only one position higher than me, and that's the CIO, and I don't have any understanding of him leaving his job. And it's not a guaranteed job. I have to apply for it, but I just took my job last May. So in the near future, I don't see that happening.
All right. So, Mr. Moore, there's been a lot of talk and opening about this job you had as a part-time job. Where was that?
It was at this, that, and the other, the Smyrna location.
This, that, and the other?
Correct.
Okay. And what did you do for them?
I'm just a store clerk where I just ring up customers and help retrieve items for customers.
All right. And is that like a retail tobacco shop?
Correct.
All right. And can you sit closer to your mic, Mr. Moore? Because you keep fading in and out for me. I don't know if it's happening to anyone else.
Yeah, he starts out low and then you can hear it. So it is doing that.
Okay. So, Mr. Moore, please try to stay close to your microphone so the court can hear you better.
Okay.
So, Mr. Moore, there was some testimony that you had that job for 5 years. Tell the court, you filed for divorce against Mrs. Moore, correct?
That is correct.
And in your divorce complaint, what was the date of your separation from Ms. Moore?
If I can remember correctly, it was February 2019, I believe. I think that's somewhere in February 2019.
All right. Well, Mr. Moore, I've got access to your pleadings from your divorce case.
Mhm.
I think the court has records of it as well. If I said that your divorce complaint said that you alleged the marriage was separated in July of 2018, would that be correct?
That is correct.
And then in your wife's counterclaim, Ms. Moore's counterclaim for divorce, did she allege that the marriage that you were lived in a bona fide state of separation in February of 2019?
That is correct.
So that's 5 years from this month, right?
Yes, it is correct.
So when you started that part-time job at the tobacco shop, you were already separated, correct?
Correct. I started the part-time job when we were separated. Correct.
And so why did you get that part-time job then?
Because I was maintaining two households, and I just needed some income to supplement what the new expenses pretty much.
Right. So that wasn't a job that you had with her while you were together to support your combined household?
No.
And when you first started there and every year since, have you ever worked a full year or has it been on and off?
It's on and off, simply because for the summer, I've been able to get the girls for the entire summer. There's no way I could work and take them to and from camp and, do everything I need to do. So I have to step away, for the summers for sure.
So in the last 5 years, what's the fewest months you ever worked at the tobacco shop?
I would say maybe 5 months out of the year.
All right. And when you were when you got divorced, what were you ordered to pay for child support?
It was 606.25 per child. So it's like $1,212 or something like that.
So just over $1,200 for child support?
Correct. That is correct. And I pay for the benefits.
Yeah, I'll get to that in a second. And then how much were you ordered to pay in alimony?
It's $700. But what's on record is 600 because we worked something different out as it pertains to a timeshare we had.
So in other words, you paid her $700, but you covered her share of the timeshare?
Until the alimony is over. That is correct. That was the agreement that we agreed upon.
And when is your alimony obligation completed?
December this year.
Okay. So when you first got divorced, Mr. Moore, and you were ordered to pay over $2,000 a month in support, spousal and child support, how much do you net per month from your job at the Department of Labor?
Then or now?
Let's just say then, because
then
or
it
better
was,
yet, Mr. Moore, go ahead and how about now?
now I net like 1,800 after everything is taken out. So it would be like $3,600 a month.
All right. That's what you bring home.
That's what I see. That is correct.
All right. And until this court changes its order, in this case, you're obligated to pay almost just about $2,000 a month in support, right?
Mr.
That is
Campbell,
correct.
can you put the paycheck back up so I can see the net and why the net is?
Yes, Judge, thank you. Let me get that. Can you see that, Your Honor? So it looks like your net pay for this check, Mr. Moore, was $1,853.96.
That is correct.
All right. And it was it close to that amount back 5 years ago?
No, it was not.
All right. So you started to explain. Do you recall what you're in the child support addendum when you first got divorced said your income was 75-74? Did that include your pay for the Department of Labor and your part-time job?
Yes, it included that amount, and I didn't have custody of the kids, so I did work a little bit more back then. I did.
All right. All right. So you all saw that, Judge, now?
Yes, I see it now. Thank
All
you.
right. All right. So, Mr. Moore, before we talk about your current leaving the job, just remind the court why you worked a part-time job over the last 5 years since your separation and then your divorce in 2021.
I mean, the simple answer is that I was married and there was a combined income. And then once we separated and we got a divorce, I'm obviously paying more out and I don't have any help. So I needed something to supplement the income.
Okay. And now you have custody of your older daughter?
That is correct.
All right. And try to stay close to your mic.
Okay.
Were some of your hours at the tobacco shop on weekends?
Yes, it was.
All right, you're still fading out. All right. And now you still have Skylar every other weekend, right?
That is correct.
And are you trying to be home during the week now that you have Sine?
Yes, I am.
All right. And I'm gonna just do the best I can. If everybody else can hear him, then I'm gonna stop
Yeah,
there.
I can hear it.
All right. So, Mr. Moore, tell the court in your own words why you recently left this job.
Well, it was two reasons. One, I have Sine at home with me, and I thought that, I could be able to maneuver and work, but obviously that's not the case. And the second part is that this job that I have now, at the Georgia Department of Labor, it requires me to, I'm on salary, so it requires me to stay at work if I need to. And it conflicts with my schedule at the tobacco shop. So sometimes I would not show up at work, or, I have to call them and tell them I'm not able to make it, which obviously they want me to be there to, it's a small business, and there's some conflict there. And so instead of, me having a situation where I can't show up some days I can, we just mutually agreed that it would probably be better if I just start working, and it benefits because I'm at home with my daughter at this point.
And Mr. Moore, since you've worked out a consent parenting plan where you now have custody of Sine, and how old is she going to be in July?
She'll be 16 years old.
All right. So do you anticipate having to pay child support for her anymore?
No.
All right. All right. So,
Hello?
yeah, can you guys hear me all right?
Yes, uh-huh.
Yeah, Judge, I'm just going on to my next question.
Okay.
So, and I'll just try to go through these quickly, Judge. So, Mr. Moore, I've shown the court your financial affidavit with your income in it. Just quickly, is this a true and correct copy of your resignation letter to the tobacco shop?
That is correct.
So, Mr. Moore, do you intend on going back there as soon as this case is over?
I do not.
All right. Are they, do you know if they've already found your replacement?
I'm sorry, Your Honor. You're asking him if this is his resignation letter. This looks like the response from the.
Oh, I'm
employer.
sorry, I got the wrong one. I'll switch gears here. Thank you, counsel. Let me get out of that one here. Sorry. Mr. Moore, is this your letter to them?
That is correct.
All right. And you sent that just over a month ago?
Yes, I spoke that. That email is to the general manager, and I spoke to him personally.
All right. And like I said before, Mr. Moore, well, before I ask any more questions, Judge, I'm going to introduce this as Plaintiff's Exhibit 2.
No objection.
So, Mr. Moore, when you live at the house with your cousin, how much do you pay in rent?
At this time, I don't pay him anything. At first, I used to, but now, we don't have an agreement anymore because he's trying to help me get ahead, pretty much.
All right. So, Mr. Moore, is it your goal to try to find your own private accommodations for you and your daughter?
Yes, sir. That is the plan.
All right. And have you looked to figure out how much it's going to take you per month to get a place?
I've researched some, but I haven't concretely did anything to move forward with anything. No, not at the moment.
So, Mr. Moore, I'm going to show you what's being marked for identification as Plaintiff's Exhibit number 5. Or better yet, we'll take a look and see what this one is. Is this a copy of a proposed child support worksheet that you prepared for your daughter that would show what Mrs. Moore would pay you based on her recent, the information we got from her counsel on her income?
That is the one. Correct.
All right. Now, in your child support addendum that was attached to your divorce complaint, it showed your income as $75,414, correct?
That is correct. Yes.
And it had Mrs. Moore's at 4308. Is that correct?
That is correct.
So this information that's on this worksheet for Mrs. Moore is less than she made 2 or 3 years ago, correct? I'm sorry, Mr. Moore, I don't know if you answered or not.
I think he's frozen.
Oh. Because I can't see him when I got the document up.
Okay, I think he's back now.
Mr. Moore,
I'm sorry.
Can you hear me, Mr. Moore?
Yes, I'm here. Uh-huh.
So this number on this worksheet for Miss Moore's income is lower than it was when you all got divorced. Is that right?
That is correct.
And this is your base this is your total income from the Department of Labor, correct?
That is correct, yes.
And it does not include any overtime?
No, I don't work overtime at the Department of Labor.
No, I'm saying it doesn't include any part-time. I'm sorry.
Oh, no, it does not.
All right. So this would have Mrs. Moore paying you $512 a month.
Correct, yes.
Judge, we're going to move to introduce plaintiff's exhibit 5.
Okay,
I don't know if they filed it as, I guess I have no objection to them introducing this as their proposed worksheet.
Yeah, Judge, this is just for demonstrative as a proposed worksheet.
okay.
All right. So then, Mr. Moore, I'm going to show you it's been marked as plaintiff's exhibit number 6. And Mr. Moore, is this another proposed child support worksheet on what you would pay Mrs. Moore for child support for Skylar based on those same numbers?
That is correct.
And you would be paying her $764?
That is correct.
All right. And then, and sir, you provide the health insurance for both children,
Yes, I do.
and that's accounted for in these worksheets?
Line number, I think it's 8. Yes, line number 8.
Judge, we're going to move to introduce plaintiff's exhibit number 6.
So
No,
admitted,
no objection.
right. So admitted for demonstrative purposes.
All right. Were you supporting your family even during separation without a court order?
Yes, I was.
Objection, relevance.
Just
Judge,
saying,
it
it
pardon me?
doesn't matter what his response is.
Pardon me, Judge?
It doesn't matter what his response is.
All right, I'm just trying to ask the judge that he's always paid what he was supposed to pay,
Okay.
and then some. It's not, all right, I'll wait for argument, Judge. Mr. Moore, you filed the case for modification almost 2 years ago, correct? In May of 2022?
That is correct.
And your daughter, attached to your complaint, your daughter filed an election affidavit, is that correct?
That is correct.
And based on the bond conditions that were placed in regard to the criminal case, your daughter was going to live with you anyway, right?
That is correct.
Objection, cause for speculation, Your Honor, because she wasn't living with him initially, and also
Yeah.
leading.
All right, Mr. Campbell, if you can ask a non-leading question.
Thank you, Judge. I'll rephrase it. So, Mr. Moore, Sanae's been at least living with she's been at least living with you full time since last May, correct?
That is correct.
All right. And you had as a result of the fact that you filed for a modification of custody, even with your daughter's an election, you've also incurred fees to pay the guardian?
That is correct.
And have you incurred attorney fees to go ahead and try to get this custody modified?
That is correct.
Okay. Are you asking the court to award you attorney fees as a result of that?
That is correct.
All right. Judge, I can wait until the court gives us some instruction on if you want me to introduce my financial Mr. Moore's billing statement.
No, not right now.
All right. Judge, I think that's all I have. And Mr. Moore, you'll pay whatever the court orders you to pay for child support, correct? I mean, somehow you'll get it done, right?
That is correct.
All right. Judge, that's all I have for now.
I'm gonna keep my video off for just a few minutes so I can take a snack, but stay on target, okay? So,
And Judge, I'm sorry, I just had 2 questions I forgot to ask if counsel let me just make them, they're a little short.
Okay, go ahead.
Mr. Moore, I forgot to ask you, when you were working at the part-time job with the tobacco shop, what was your hourly rate?
$16 an hour.
And what, when you were, before you had your daughter live with you and when you were working your most, what was your average hours that you would get in over there?
Like 28 hours a week.
How many?
28 hours.
So what was the,
How many hours?
28 hours. 28.
was that your average or was that high?
That's the highest I would work.
So what was the average though? I'm asking you, on a normal week, what would it look like? Not your most you ever got.
Oh, I mean, like it's like 20. It was 20 as of when I resigned. It's like 22 hours, 20 some weeks would be different, just contingent upon what time I left my regular job.
All right, I'm just trying to make sure I understand your testimony. So on an average, what was your average per week? I heard you say three numbers, 20.
22 hours. I thought you were asking me at the beginning at my highest peak is what I thought you were asking me. But most recently, I was working at least 22 hours a week.
22.
Correct.
It's okay, $16 an hour.
Correct.
All right. And did they take taxes out?
Yes.
All right. Thank you, Judge. Thank you, Counsel.
Okay. Ms. Foster.
Yes, Your Honor. So, Mr. Moore, you've just testified that you started working this part-time job in 2019, correct?
That is correct.
Okay. And your divorce was finalized in November of 2021, correct?
That is correct.
So prior to any alimony or child support being ordered by this court, you were already working that part-time job, correct?
That is correct.
Okay. Now, and your daughter, you testified, has lived with you for the past year, correct?
Not the past year. Since school got out last year, May 2023 is when she started living with me.
Okay. And so you've had, in essence, custody of your daughter since May of 2023, correct?
That is correct.
And even while you had custody of your daughter since May of 2023, you have continued to work that part-time job, correct?
No, I did not work the part-time job in the summer. I picked the job back up in the fall.
Okay, well, let's talk about that because you submitted your pay stubs for your part-time job, correct?
That is correct.
And your testimony today is that, you worked approximately 5 months a year. Is that correct?
Somewhere, but not correct.
Okay. I'm going to show you, this was your attorney's exhibit, but so it's been marked as respondents 2. Actually, maybe this is our exhibit. Okay, Mr. Moore, can you see my screen?
That is correct.
Okay, and this paycheck, this is for your part-time job, correct?
That is correct.
Okay, so as of, and this
Kind of
looks
small, so I can't see it, just in case you're
Oh.
not mindful.
let me try to make this bigger. Is that better, Your Honor? Is that better, Your Honor?
Does that say 1554.80?
Yes.
Okay, then I can see it.
Okay, so now, Mr. Moore, this paycheck period, this check is dated November 2nd of 2023, correct?
That is correct.
So as of November 2nd of 2023, your year-to-date, actually, Your Honor, before I go into this, I moved to admit R2 into evidence.
No objection, Judge.
R2? All right, R2, so admitted.
So, Mr. Moore, so as of November 2nd of 2023, your year-to-date is $13,399.84.
That's what it says.
Okay. And you approximately made in this pay period $1,554.80, correct?
Sorry, say it again.
Can you hear me?
Yes.
It looks like I'm having a hard time hearing you. I'm sorry. Is that, so the amount made for this pay period was $1,554.80, correct?
That's not correct because that says $27. I mean, I'm sorry,
I'm
27
sorry, yeah.
hours. Yeah. So yeah,
Let
no.
me back up. I'm sorry. I'll rephrase that. Let me actually ask you this. You testified that you made $16 an hour, and you worked approximately 22 hours a week, correct?
Most recently, yes.
Okay. Now,
Mhm.
in Discovery, did you submit all of your pay stubs for your part-time job?
I submitted what they asked me to.
Okay. Now, the first hearing of this, for the final hearing on this case was on November 6th of 2023. Do you recall that when we were in court?
I've been to court 1,000 times. I'm be honest, I don't remember, but I'm sure I was there.
Okay. So as of November 6th of 2023, you were still working the part-time job, right?
That probably is correct. Yes.
Okay.
Last
And
year, correct.
okay. And then this case was rescheduled for December. So as of December of 2023, you were still working your part-time job, correct?
That is correct. Yes.
Okay. And then you were aware that the only issue left for this court to decide was child support, correct?
That is correct. Yes.
So tell me why you all of a sudden in January of 2024, January 7th of 2024, when you knew that this court, the only issue was child support, that you all of a sudden, even though you've had your daughter since May, you've been working this job since you were married, why did you all of a sudden now decided that you were going to quit your job?
Well, I didn't all of us. So I didn't quit it. If we go back a little bit, I've worked the job on and off for 5 years. And so it's never been consistent where I work every single day. As of recent, as I said earlier, when I first started, when I picked the job back up in the fall after Sine started school, I thought that I could be able to work it out, but obviously that wasn't the case. And what also happened is when I started my job back in May, I was new to the job. I wasn't working my part-time job yet. I picked it back up in the fall. So once I got acclimated to what I was doing, I was fine. But at this point, in this juncture where we are right now, we have a lot of stuff going on at work, and it's my primary job. So if I had to choose to take one job or the other, it would be the one that pays me $6,500 a month and not the one that pays me $1,300 a month. And so the tobacco company is a small business. Obviously, they don't have thousands of employees. So there was a conflict between, me getting off work and them not having enough people to schedule at the job. And so respectfully, I did the right thing. You just told them, hey, you know what? I'm not spending that much time with my child. I can't quit my regular job because that is the job that pays the most money, so that, I don't have any conflict. You have people at work that you can depend on, not so much me because of, my obligation to stay at my permanent job, because I can't tell them, no, this is what I need to do. And they respectfully agreed and understood exactly where I was.
So, Mr. Moore, so since 2019, you've worked at your permanent job and this part-time job, correct?
Yes, I have.
And in Discovery, and when we asked you to submit all the information, did you submit anything that now your part-time job that you had was becoming a conflict with your regular job?
No, I mean, it's not a conflict every single day, but there has been conflicts. Yes.
Okay, but even though there have been conflicts for the past 5 years, you've worked that job consistently for the past 5 years.
I have not worked it consistently. I have worked it on and off. Because like I stated earlier, in the summer, I take the entire summer off. So in order for me to do that, I can't be working. And so I take the entire summer off usually. And when I didn't have kids, I would pick the job back up. But now I realized that it's just not going to work that way. I was just trying to supplement my income, and it's not working the way that I thought it would. And so to me, to be honest with you, I think if you look at it, there's no way that I could say I quit my job so that I didn't have to pay on $1,300. That's not what happened. What happened is that there was a conflict and I wasn't spending time with my child. Actually, I get my child every other weekend. Some of the weekends I would have to work. Some of the weekends I wouldn't. So it was a problem before. no one questioned me about it. So I didn't feel a reason to go into detail about why I, worked on and off at a part-time job. Again, I don't make $45 an hour. I make $16 an hour. Didn't think it was a big of an issue.
Mr. Moore, you would agree that since this case has been pending, and child support became an issue, you would agree that you have consistently tried to make your income appear less than what it actually is, correct?
Objection, Your Honor.
Correct.
That's argumentative. There's no foundation for that.
I'll
Yeah.
ask this another
Yeah.
question.
Okay, go ahead.
I'm sorry. You submitted several financial affidavits in this case, correct, Mr. Moore?
I've submitted several, and all of them been consistent. That's what I can
Okay.
answer to. Yes.
I'm going to show you what I'm going to mark as R10. Can you see my screen? I'm going to make this bigger for the court.
I can see it. You actually take it back where it was. It was fine where it was.
Okay.
That's fine.
And Mr. Moore, back in 2022, this is your signature. This is Dontaria Moore, correct?
Correct.
And this is dated November 15th of 2022,
That is correct.
and it's notarized, correct?
That is correct. Yes.
Okay. Your Honor, I move to admit, I'm going to R10 into evidence.
R10.
Judge, I'm just going to object because this was not introduced today in this hearing on child support. It may have been produced at some other point, but without knowing when this was submitted, he's just testified what his current income is during this hearing. And child support's been an issue since this case started, not just this month.
Your Honor, it's for impeachment. We just found out that he apparently quit his job. We just got the information from his attorney on Monday. And so
I'll
now,
allow for impeachment purposes. You may proceed.
thank you. And so, Mr. Moore, you initially, even though you've been at the same job, and your income was $7,574.53 when you got divorced, you swore under oath that your income was $5,050.90, correct?
I submitted that probably was my income. That was probably around the time that I did not have the part-time job. But that same worksheet for when I got divorced here in Mrs. Baree Court says 7,500. So it has changed because, again, what I'm consistently telling you is that sometimes I work the job and sometimes I don't. So that is probably accurate when I submitted that. But when I got a divorce, that was not the affidavit. The affidavit that I signed when I got a divorce was $7,500.
But Mr. Moore, you just said today that your income without your part-time job is $6,579, and you testified that your income did not change. So this $5,050 is less than what your actual salaried income is without your part-time job.
And Judge, I'm going to object. I think she mischaracterized the question. He had testified that his income is not going to change going forward. I never asked him if it never changed from the past.
But
It has changed. I got a promotion last May, so it has changed. That is correct. I got a promotion.
Ask another question, Foster.
yeah, so you're saying that your income, you got a promotion, but your income in 2022 was less than what it was in 2021?
Judge, I think the question's answered. He testified that that was his income at the time of his Department of Labor job without any part-time income.
Okay, I'm a little confused. Ms. Foster, ask the question again.
Yes. In your divorce affidavit that you submitted that your income was $7,574.53, correct?
Yeah, I'm not sure what you're asking me, but what I remember is when I got a divorce, it said $7,500 some odd dollars. That's what I remember. What you just showed me, what looks like a document that probably was submitted maybe in between me working another job. But I guess what I'm confused about is that what's consistent is that I submitted the correct information when I got a divorce because it's based on 7,000 and not 5,000, which is more. And I got a raise last year, which would ultimately change it again because that was in play as of last May. I'm not sure about the exact dates and the numbers and everything, but what I can tell you is that I have a signed affidavit from Judge Marie where it says $7,500. That's what I submitted. At the time I submitted that, I did not make the money that I make right now. That was based on approximately $60,000 or so dollars, plus me consistently working at that particular time at my part-time job because I didn't have custody of my kids. So then those
Wait a
numbers
minute,
are
come
correct.
back, wait a minute, now that doesn't make sense. You just, that 5,000 could not be both jobs. Even
No, it wasn't both jobs. But what I'm saying is I don't know definitively when I submitted that if that had anything to do with my divorce, because when I got a divorce, it was $7,500. I can't dispute that. It was $7,500. So the old thing that she's bringing up, I mean, I don't know. It's not the most recent thing. So that could be correct. That's all I'm
Right,
saying.
Ms. Foster, go ahead and move away from this. I understand your position.
Yes, Your Honor.
Mhm.
And so, Mr. Moore, you would agree, and just to kind of go back, you mentioned that Ms. Moore's income was less. You would agree that after the incident happened with your daughter, you waited 2 weeks to call the police, correct?
It was actually longer than that before I reached out to the police.
Okay, and you reached out to the police because you wanted her to be arrested, correct?
Judge, I'm gonna
That is-
object,
that-
Judge, I'm gonna object because I could have done a lot of this in direct and we said these issues were resolved. So, if we're gonna get,
What's the relevance of that to
Yeah,
child?
it's for impeachment. There's always been an issue with child support. And after he reached out to her after the incident occurred, there was a disagreement between the parties. And then he decided to call the police, which caused my client to lose the position that she has, which is why her income, I mean, I can go into this with her, but that's why her income has went down.
Okay.
and Judge, and I could,
I can handle that with her.
Okay.
Mhm.
And Mr. Moore, you currently have an open aggravated assault case pending where Ms. Moore is the victim, correct?
That is correct, yes.
And you would agree that in filing this modification case, would you say that it was to kind of get the upper hand on Ms. Moore?
No, the reason why the case between Sinead was filed was that at the time the incident happened, including Miss Moore, she was at my house for testing purposes. When the incident happened, Sinead told me that she didn't want to go back home. And so it was, I think it was like spring break or something. And so during that time, she stayed with me. Mrs. Moore didn't have an issue with it. But around the time when it was time to go, go back or agree to what we're going to do for the summer, Miss Moore indicated that I guess she thought that I was trying to kidnap my child, which wasn't the case. And so what happened is that I called Attorney Campbell to get his advice on what to do, because what it appeared to be was that I kidnapped my child and I would not return her. And that's absolutely not what happened. What happened was she allowed her to stay. And at some point there was a disagreement, but it was nothing more than just a disagreement. And I was trying to protect myself, which is why I called Attorney Campbell and I called down with the police so that they could get the story about what actually happened and that I did not kidnap my child.
Mr. Moore, since this modification case has been pending, have you paid your child support to Ms. Moore as ordered?
Yes, I have.
Okay, were you current on your child support as of November of 2023?
Yes, ma'am, I was.
Your testimony under oath is that you were consistent on your child support as of November 2023?
Yes, ma'am, I am.
Okay, and you would agree that you've asked Ms. Moore several times to take you off of child support?
I have not. When the only time
Say that again?
I said I have not. She asked was that I asked Miss Moore several times to take me off of child support. That isn't correct. What happened was when we got a divorce in Miss Barree's courtroom, the only thing I asked the judge was to take me off of state ordered child support because I put myself on child support because she was asking for an astronomical number. And so I said, the only thing that I want in my divorce is to be taken off support coming through the state because that was never necessary. She never put me on child support. I put myself on child support so that I can ensure that I was giving her the correct amount of money. So if you go back and you check the records, you could see that that's the only thing that I asked for. And Ms. Barree was the judge on that case.
Yeah, and I have no further questions for Mr. Moore.
Okay. Mr. Campbell, do you have any follow-up?
Just real quick, Judge. Mr. Moore, on that issue about that affidavit that Ms. Foster brought up, was it your testimony that that affidavit could have been in a period of time when you weren't working part-time?
Objection leading.
Oh,
That's
yeah,
what I was trying to
ask a different question, Mr. Campbell, not non-leading.
Mr. Moore,
Mhm.
do you recall when you filled out that affidavit that you were shown, remember if you were working part-time or not?
Don't remember, but according to the number, there was no way that I could have been working a part-time job because that looks like it was my Georgia Department of Labor salary back then. That was just the salary itself.
All right. Mr. Moore, did you quit your job recently with the, I heard your testimony and it was very detailed, but just to get to the point, did you quit your job at the tobacco company solely because of this case?
No, absolutely.
That's all I have, Judge.
Just one brief follow-up, Your Honor. Mr. Moore, you can go back to your tobacco company job at any time, correct?
I could go back to probably any job that I apply for. But are you asking me if I left on good terms where I could return? Yeah, that answer is correct. Yes, I could go back if I chose to. Yes.
Now, in fact, you submitted the response from your employer to your resignation letter, correct?
That is correct.
And you are always welcome to return at any date, a later date, if you wish to do so, correct?
That is correct.
So after this hearing, after the court rules, you can decide tomorrow to go back to this job, correct?
I could decide to work that job or any other job.
Okay. No further questions, Judge.
Judge, one last one then.
Yeah, no, we're gonna move on. Mr. Moore, how many times have you left the job for extended periods? Like, for example, I said that there was one time
I
that
think
you
I've
did
left
not
at least
go-
4 times.
you would not work during the summer. How often have you gone in and out of this job?
I think the correct number, Your Honor, is 4 times.
You've done this 4 times?
Yes, because I have to get my kids for the summer, so they allow me to take off work so that I could get my kids for the summer. I can't take them to and from work in summer camp and be a father working 2 jobs because I have 2 kids here with me.
Okay,
So
you-
that's not
you
possible.
always pick off during the summers.
Yes, ma'am. That is what I'm saying. Correct. And sometimes when we have like, spring break or whatever, like we went to vacation for Christmas. I wasn't at work then. They allow me to take off to spend time with my kids.
That's different. That's a vacation. That's not
Yeah.
resigning from a job. So are you resigning or do you vacation? Which one is it?
The most recent one was a resign because of what I said. I'm not spending time with my child. I can't get there some days. So that is the reason why I resign.
And when you're doing the summer, do you send them a formal resignation letter like that during the summer?
No, we have a discussion that, hey, I'm getting the kids this summer. I won't be able to work this summer. I'll pick back up in the fall whenever I get everything situated and settled. That's usually the conversation. But again, I've been working there 5 years on and off. And so I've been doing a great job. So there's no issue. They just looking at me as a single father trying to, make some money. That's it.
What is the conflict specifically?
My Georgia department, Your Honor, I'm a security administrator. If something happens at work, I have to stay after hours, right? So I give you an example. 2 Thursdays ago, we had to do some security patching, right? It was something that wasn't scheduled. It was an emergency. There is no way I could leave my job that pays me, $6,500 a month to go to a job that pays me $16 an hour. So what happens is I say, hey, listen, I don't know how long this is going to be, but I'm definitely going to be late. I'm not already working, like 4 hours for the day anyway. And so usually they have to find someone to come and replace me. And because I think they have respect for me and I'm doing it the right way, I give them as a notice as soon as I can. And that's usually what happens. And so what I said to them was, hey, listen, so we can avoid this. And so we could avoid me not really spending time with my teenager daughter that obviously needs me there in the afternoon. I'll have to resign. And respectfully, they understood.
Okay, so your position is that you do not plan on working any other job because that job, any other job you work would do the same thing with conflict. right?
That is correct. The Georgia Department of Labor is my bread and butter. I can't take any job over that.
Okay, all right, thank you. All right, anyone else, Mr. Campbell?
Judge, I think I'll just wait on cross for Miss Moore. If
All right,
Miss
Ms.
Foster intends to call her, if she doesn't, then I'll call her.
All right,
Yes, I am calling her.
Mhm.
You're gonna call Shantaria Moore?
All right, Ms. Moore, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may proceed.
Okay. Ms. Moore, I'm gonna kind of just get right through it. Now you were arrested in 2022, correct?
Yes.
How long after the incident occurred were you arrested?
It was about 2 weeks, or
Okay.
maybe a little bit over 2 weeks. Not
Okay, and
not
what-
3, but
Okay. And now tell me, prior to this, was there any discussion or disagreement between you and Mr. Moore about anything involving child support or your daughters?
I sent him an email because he said that Sine was not coming back with me the day that I left his home. So I sent him an email stating, and I wish I had known this was gonna be brought up. I could have forwarded you emails, but it was basically saying that I was coming to get her.
Okay.
I never
was
said
there-
anything about kidnapping or anything like that, and he knows that.
Okay. Was there a discussion or issue or anything about child support?
No.
Okay. How long after that incident did he, or you already answered that 2 weeks, so I'll move on. Now, did that charge that you were charged with, did it affect your employment in any way?
Yes, ma'am.
How did it affect your employment?
Because I could not get my license that I need to work. So I
Okay.
was facing termination. It was either find a position within the company that does not require a license or be terminated by February 15th.
Okay, and what did you do?
I found a position within State Farm.
Okay, I'm showing you what's been marked as R5. Can you see my screen?
I can.
Okay. And Ms. Moore, what is this?
That's my acceptance, my contingent offer
Okay, this is the new position that you're talking
for
about.
the new position. Yes.
Okay. And is this the document that you submitted to me?
Yes.
You're gonna move to admit R5 into evidence?
R5, Mr. Campbell.
Yes, Judge, can we just see the bottom of the document?
Okay,
I think we need to go up a little bit. Because it's more than one page, isn't it?
Yes,
that is the second page, it looks like, at least.
yeah, this is the second page.
But if you go up a little further,
Oh, it's cut off. I see what you're saying. But this is what we sent to you, Mr.
no,
Campbell.
I just saw it. If you scroll down, I think on the bottom of it, there is a question about her, right there.
Yes, I'm gonna ask her about it in a little bit.
All right, I just want to make sure I saw this was the one that had the number on it. Yeah, no objection, Judge.
All right, so admitted.
So, Ms. Moore, is this in this offer letter, it says what your new income, this 42,818.75, is that your new income?
Yes.
Okay. And you submitted a financial affidavit to this court, correct?
Correct.
I'm showing you what's been previously marked as R4. Do you recognize this?
Yes.
Okay, and at the bottom of R4, is this your signature?
Yes.
Okay, and you're gonna move to admit R4 into evidence?
No objection, Judge.
All right, so admitted.
And Ms. Moore, in your gross monthly income, you used the $42,000 number of what your new offer is, correct?
Correct.
And again, and this is the position that you're working in currently, correct?
Yes.
Okay, now let's talk a little bit about Mr. Moore's part-time job. How long have you known him to have that part-time job?
He got that part-time job before we separated or
Okay,
during separation. Because I mean we were on and off. So when we
okay,
separated and still together, he still had that job.
okay. So since 2019, you have known him to consistently have that job.
Yes,
Okay, and you your discussion with your attorney in the child support worksheet that you wanted to submit to the court, you included his part-time job that you've known him to consistently have for the past 5 years, correct?
correct.
Okay. And actually, before I show you that, what has happened to the criminal case that was brought against you?
It's been dismissed and sealed.
Okay, and I'm showing you, it looks like, I'm sorry, Yana, I marked one R10. I should have marked it as R11. I believe it was, actually, maybe I didn't. I think it was R2. Yeah, I didn't. I'm sorry. I'm showing you, Ms. Moore, sorry, Your Honor, what's been marked as R10. Do you recognize this?
Yes.
What do you recognize it to be?
A document saying that my case has been dismissed.
Okay. Your Honor, I move to, I'm sorry, I move to admit R10.
All
No
right.
objection, Judge.
Okay, so admitted.
And so you worked with your attorney in preparing a child support worksheet, correct?
Correct.
Okay, I'm showing you what's been marked as R6. Do you recognize this?
Not really, but I mean,
It's okay. Do you recall that we discussed child support and child support numbers?
yes,
Okay, and you may have not seen it, do you recall that items are uploaded to your portal for you to review?
yes,
Okay, and does this still not look familiar to you?
Judge, we'll admit it for demonstrative.
yes, yes,
Okay.
All
Okay.
right, for demonstrative purpose, so admitted.
Okay, and so Ms. Moore, your income in this child support worksheet is listed as what you put in your financial affidavit, $3,581.95, correct?
yes,
And you're asking this court to impute Mr. Moore at $8,134, correct?
correct,
And that is the number that we got in reviewing the information that he submitted as to his income, correct?
correct.
Okay. And then once Sine graduates from high school, I'm going to show you what's been marked as R7. Here I move to admit R7 for demonstrative purposes.
Any objection, Ms. Campbell?
I'm just trying to figure out what counsel was just trying to explain what this was.
Well, Your Honor, we have
After, this after Shanae graduates from high school.
So this is just for the one child?
Yes.
yes.
No objection, Judge, for the same demonstrative purposes.
All right, R7 admitted demonstrative for demonstrative purposes.
Okay. And Ms. Moore, you're asking the court to, again, use the numbers that we've submitted to the court to calculate child support for after Sine graduates from high school, correct?
Correct.
And Your Honor, I have no further questions.
All right, cross.
All right.
And I'm sorry, Your Honor, you did say that we had to hold any attorney fees
Yeah, we'll deal with
information
that
for later. Okay.
Good afternoon, Ms. Moore. My name is Rick Campbell. I'll just have a few questions for you. So, Ms. Moore, is it your allegation or is it your testimony before this court that it's Mr. Moore's fault that you were charged with cruelty to children?
Yes,
So you deny the fact that you punched your daughter in the face when you came over to the house because she was gone for a while and you didn't know where she was?
I did not punch her in the face, and he called me and said that she left without permission.
Yeah. And what did you do when you walked in the door? and you saw her sitting at the kitchen table.
Objection, Your Honor, relevance is to the facts of the case that has now been dismissed. And
The
I
judge,
know
counsel
I
brought it up, and she.
I brought it up in that he called 2 weeks later, not the date of the incident. I didn't go into with her the details of whether, of what
Yeah,
happened.
I don't think we need to go into the details of it, okay?
And the only reason why.
The reality is that her income lowered was not voluntarily lowered. Her position is that she had an outstanding issue and it had to be,
No,
she
I get it,
was gonna
Judge.
lose her job completely. So his child support would be higher. So I don't
The
think
inference
we
though,
need to
Judge, was that,
argue that, right?
no, Judge, the inference only was, it was only lowered because my client did something against her when there was video evidence of the reason why she was charged.
Yeah, I think that position, I understand the position. I understand the further analysis that you're going, but I think
Yeah.
I understand Ms. Foster was basically saying that because he waited for 2 weeks, it looked like it was ulterior and not for another purpose.
Right.
You're right. Ultimately, Ms. Moore is responsible for her own actions. I think she was looking at the fact that Mr. Moore called so late and she was questioning his motives, not necessarily who was accountable.
Right, Judge, but the point is, we didn't get equal time to go into those motives and go into explain
Well,
any.
you could have asked him why. She did ask him why he waited 2 weeks, and you objected. And so then I said, okay, well then move on. We'll let Ms. Moore testify to it because I think that was in fact her question. Why did he wait? And you objected to it.
And I was just trying to steer away from all that, Judge, but
You
we
could
had.
ask him why he waited, but I just don't think we need to go into whether she slapped her, or punched her, or kicked her, or whatever it was. I think
Right.
that is unnecessary. I think the
No,
real issue is that whether her income changed as a result of something she voluntarily did, was she trying to manipulate child support and work less? And I think that's really what that issue is. It's not really related to anything else.
Well, thank you, Judge. I just didn't want the court to think that she was losing income because my client caused it to happen.
It really doesn't even matter. I'm not thinking in that regard.
Right.
I'm looking at what her numbers are. Her numbers are what they are.
Right.
And only if they've been manipulated would the court impute a different number.
Thank you, Judge.
All
So,
right.
Ms. Moore, isn't it true that at the time of your divorce, your the child support addendum had your income listed at $4,308 a month?
I'm not sure at the time of the divorce. That's probably right.
Okay. So, and now you're at $3,500 a month?
Correct.
So just less than $1,000 lower than it was back then.
Right.
Right. And you just testified that your criminal charges have been dismissed and sealed.
Correct.
So will that now free you up to get a different position that's not restricted at State Farm since you no longer have any of those issues remaining?
That is correct.
So what do you anticipate your income is going to go up to?
I have no idea because I haven't applied for another job.
Mhm.
And then I have to wait a 12-month period before I can even move positions.
And you haven't applied for any other type of job anywhere else that makes more money than $3,500 a month?
No.
But it is your testimony today. And the reason why we're here is because, in fact, isn't it true that when you're at your State Farm job, even before this incident happened, you averaged barely 40 hours a week, right?
That's because our work schedule is 37.45 hours.
Yeah, so it's
We
just
don't work a full 80-hour period.
for 2 weeks, you mean?
Right.
All right. So you barely, it's true then, on a regular work week, you get less than 40 hours.
Yes.
All right. But you're asking this court to base child support on Mr. Moore working 65 hours a week. Isn't that right?
No, if you actually
Yeah.
go back and look at my pay
Objection.
stubs, I was working
Moore.
overtime.
Ms. Moore, objection. Your
Oh.
Honor, he is assuming, I guess, facts, not in evidence. We just used the numbers that Mr. Moore submitted to us.
No, Judge, I'm on, Go ahead, counsel, I'm sorry.
She's not asking you to impute him. We use the child support statute that says you use the numbers that he works. And I just use the numbers that Mr. Moore himself provided to us. My client's not asking you to use 65 hours. So I would object to his question as to what she wants the court to do.
Judge, I think I have the right to go into this.
I don't think it really matters. I mean, it's really a kind of a legal issue anyway, so it doesn't matter what her analysis is.
All right, and then Ms. Moore, do you have a part-time job?
No, I do not.
Okay, could you get one if you wanted one?
No, I could not.
So you're not eligible to work part-time anywhere in the world?
I have a smaller kid. Sanae is older. She can stay at home a little while longer than Skylar can.
All right, so in other words, since he's got a child at home, it's okay for him not to be
Yeah,
there.
I would object to
Yeah, I
this.
think it's argumentative. Keep moving, Mr. Campbell.
Judge, that's all I have.
All right. All right, so I got to go back to this other hearing now. So I know you all might have some arguments to make, but can you round your arguments up in 5 minutes?
Yes.
All right, 5 minutes.
can.
each.
Go
Can you,
ahead, Mr.
Mr. Campbell.
Judge, I'll reserve.
Okay, but can you do it in 5 minutes?
Judge, if you give me 5 minutes, I'll take 5 minutes, no more.
Okay, all right, go ahead, Ms. Foster.
Yes, Your Honor, I'll be very quick. Clients were having issues before this charges were brought. As you heard, Mr. Moore currently has an open case for aggravated assault where my client is the victim. And at the time that this happened, there was a disagreement. He waited 2 weeks to call the police, which brought up this whole modification. The charges have been dismissed, but unfortunately for my client, because of these charges, her income has now decreased. Also, their daughter is 15 years old. She has more freedom in her father's home. She made an election to live with her father. A guardian was appointed, and it was found, and we agreed on what the parenting plan should be. Now we're just talking about child support. Child support is purely numbers. This isn't me making up any numbers. I used the income of Ms. Moore. I used the income that Mr. Moore submitted. We entered it into a worksheet. Because there's a disparity in income, we're asking the court to use the calculation that I believe that you said that you do, which is basically just take the difference and have child support be ordered. Once Sanae graduates from high school, we're asking the court to use the same income. We believe that we have to submit pursuant to the statute 2 child support worksheets because we know that one child will age out within 2 years. So we're asking the court to use the child support worksheet that we submitted. We also submitted a child support addendum. Child support is purely numbers. I don't think that we should have had this argument about it. I couldn't help what Mr. Moore made, and he conveniently quit his job last month. He didn't quit it back in November because he intended to keep working it, even though the facts have not changed. He knew that he would have his daughter. He knew that, that she was in high school. He knew the situation. But at the first hearing in November, he hadn't quit his job. In December, he hadn't quit his job. It wasn't until the attorneys were arguing back and forth that, hey, the statute says that we have to use the hours that he actually works, including any part-time job.
Let me ask you, were y'all making it, was this the argument though that was still made in November?
Yes.
Okay, so what I'm asking is, in November, did Mr. Campbell indicate that Mr. Moore was about to quit his job? Because
No, never. We didn't
Well,
hear
Judge, I
that.
didn't-
did he argue that those numbers should not be considered?
Yes.
Okay, so his argument was in October and November hearings, his position was only consider the 40-hour job and that the part-time job should not be considered.
Yes.
Okay.
And my argument
And then
was,
you're saying he quit his job in January.
yes.
Oh.
Yes, because my argument is in pursuant to the statute, I have to use his part-time job because he's working that job. And then conveniently, last month, he's quit his job. So we'd ask the court to impute him at the income, including his part-time job, and enter the child support worksheet in the child support addendum that we submitted to the court.
Okay,
Thank you, Your Honor.
Mr. Campbell.
And Judge, if it may please the court, thank you for your consideration of our case. Judge, I think I should have made this point earlier. Judge, there's so much allegation about who did what to who and how this got started. This case, even if you throw out all the criminal charges and what went down, Sinead filed an election. She wants to live with her father. She still wants to live with her father. And it took almost 2 years. And we had to get a guardian involved just to finally convince Miss Moore, hey, your older daughter wants to live with her dad. So we spent 2 years litigating that. Then we get into the child support, and Your Honor's correct. When we got to the child support in November, we came prepared to go to court on that issue. And counsel and I traded back and forth. Our argument being, hey, we know he had a part-time job. He's going to get custody of one of his daughters. He can't be home. He can't be at work. He did it. And Judge, I think Miss Moore agreed. She separated in 2019. His testimony, which is unrefuted, I had to get this job after we split up because we had 2 households and I'm paying money left and right. I need some part-time work. So here we got a situation, Judge, when we came in, and I didn't know he quit his job in January, but we came to court prepared to ask Your Honor, not to, even if you have to consider all sources of employment, the court can deviate and pick a number that makes sense based on his 40-hour week work. She's only got a 37-hour work week. And Judge, it just seems patently unfair that she says, well, you had to go to work extra since we split up and pay my alimony and child support. So now I want you to continue to use that number, Mr. Moore. You're tied to that number for the next 9 years because you're working harder to pay support. So now you're gonna have to work even harder to make the higher number because you're working more. It's a circular argument and it's manifestly unfair. Asking her, well, why can't you work 65? Oh, I can't. I got a young child at home. But you don't care that he does it, and he changes his whole life around in order to make ends meet and pay all these monies. But so now it's not a question of, well, we don't have any choice but to use the numbers. Yes, you can. You can go ahead and work a child support worksheet to get a fair number, and you can include in any kind of deviations. There's split parenting time. There's anything. But she's basically saying, and Judge, the number, even if you go 20 hours, 22 hours a week, yeah, it's going to change his life. It's going to change the amount. But it's not her saying, you know, I've got a child. She collected child support since last May that he's been paying it even when the child's living with him. She didn't call and say, hey, I don't need this money anymore. She's not even living with me. He's been doing what he has to do. So basically, counsel's saying, Judge, I want you to tell Mr. Moore, he is forced. He doesn't have a choice anymore. He has to work a part-time job to pay higher child support, which is based on a part-time job. But she doesn't have to because historically she didn't work a part-time job. So her child support, what she pays him for Sinead, is going to be lower because she chooses to be at home. But we're taking that choice away from him. And he said a lot of good reasons. One, my alimony is about to be over in 9 months. I got a daughter at home. I like to spend time with her. I got my other daughter on the weekends. So my weekend work is shot. It's conflicting with my Department of Labor job, which pays a lion's share of the child support. But somehow he's disingenuous, Judge, because after 5 years of trying to make ends meet, he's got to live with his cousin, live on $2,000 a month. See, Judge, what I think, and I'm going to finish with this because I might be over my time. The courts are full of people saying, oh, I can't pay my child support. I can't pay my alimony. They come in under contempt. What Mr. Moore did was, I've been ordered to pay a dollar amount that's hard to pay. It's hard to come up with. I'll live with a cousin, so I have to share rooms with other adults that I'm not even, they're their family, but it's not my own house. I got to pay the child support. I net about $4,000 a month. So if I'm going to make ends meet, I got to work a part-time job. And now his ex-wife saying, well, now that you're working a part-time job to make ends meet, that's going to make my child support go up. Judge, I think the court has plenty of discretion to deviate whether you use his income or not. I don't think Mr. Moore in any way indicates he is somehow disingenuous in how he pays his money. He's always supported his kids. He only filed this case, Judge, when Mrs. Moore came in and slugged the daughter. And if you saw the video, you'd know why any 15-year-old doesn't want to live there. She elected to live with her father. He's incurred tons of fees with guardian in my office just to get the consent order we finally reached a couple months ago. 2 years, and we got an election. So Judge, I'm sorry we took so much time, Judge. It just seemed like this could have been a lot easier.
Okay. All right. Thank you so much. Like I said to you earlier, I recall having, and I haven't been able to look at that case again, but I recall, if you remember when you first got started, I was like, well, stop, wait a minute. Do we really need to go down this hole? Let me try to find that case where it basically indicates that there is a consideration when you talk about a second job and the history of it, like historically, what that second job is. Because even though Mr. Campbell, I do understand your analysis about the circular idea of it, but at some point you got to figure it out, because there are plenty of people who have second jobs, and those second jobs are considered. Your analysis would be that a second job would never be considered, because the second job would always mean that that person is submitting themselves to it and they shouldn't be held to it, even though they're making this money and they could quit it and begin it whenever they want. A second job would never be considered under that analysis. And so at some point you got to look at something else, right? So you got to look at the history of it so that you can determine whether someone is doing it to prevent themselves from paying child support, or whether there are other reasons for it, because second jobs are considered sometimes. They're not always considered, I imagine. There might be some consideration that the judge has in that. And I think one of them is looking at the history of it, and also need and other things. So I'll take a look at that. I'm going to see if I can find that case that I was talking about initially, kind of look at the nuances of it and determine essentially what that means. But I know the first case that I found that, and I think you guys can already know this is kind of basic. You're generally not supposed to quit jobs in the middle of a child support hearing. It doesn't look good. Like, let's just, it doesn't look good when you're in the middle of a child support hearing and you hear that someone has quit a job, and then they quit a job on good terms. So it makes it concerning when you have someone quitting a job. And so I understand your analysis that, he's kind of in this circular pattern and you want the court to consider something else, but I'll take a look at it. But that was the reason why initially I was like, wait a minute, he quit his job in the middle of a child support hearing. So wait a minute, let me look at that. Are we really going down this using this analysis? But I do agree, and I understand what you're talking about when you have a person who, according to you, only got a job for purposes of meeting two households and wants to not work it now. So I'll take a look at it. Let me look at some of these cases, or I haven't pulled up any cases. I'm going to try to find that original case that I was talking about, take a look at it, and I'll let you know how I'm going to proceed. All right.
Yeah, Sharon, do you want us to submit attorney fees argument?
I'm going to look at that argument first. Let me figure out what that answer is first. And then I'll send that over to you to let you know what I'm going to do. Y'all can bring me all the documents together. And then usually after that, I'll give you 10 days on the issue of attorney's fees.
Yes, Sharon.
Thank you, Judge.
Let's finish the meat of the case first, and then we'll come back on the attorney's fees issue. Okay?
Yeah.
All right. Thanks so much. Y'all take care.
Are we excused, Judge?
I'm sorry.
Oh, I'm sorry. I didn't know if you excused us.
I am. I'm excusing you now. Y'all take care.
He told the judge he had no money, which he has $70,000 that he
All
put
right,
in a bank account.
This call, how much do you make an hour?
$10 an hour.
He makes $20 an hour, and
How do you know this?
because I have bank statements at my house that I have right here in front of me.
From, wait.
But, he makes deposits every Friday at his banking account.
I make a
Hold on,
$50 deposit every
Hold on,
Friday.
Mr. Calkins. Hold on, wait, because now I'm intrigued.